This is Akashvani Mangalore. Dear listeners, in today's Talk in English program now, Sri M.N. Pai, a Mangalore-based chartered accountant, will speak on the need to write a will, sign of wisdom.
In the Mahabharata, King Yudhishthira answered to one of the questions from Yaksha. The incredible wonder in this world is a man believing every moment that he will not be visited by death, even though the truth is he may die any moment. Even after 1,000 years, this belief persists, and thus many fail to organize and arrange their affairs and wealth in such a way as to leave behind a legacy of peace, harmony, and happiness to their kith and kin. One way to avoid this is to draw a proper will, and howsoever delicate it may look, to convince oneself to have one. A will means the legal declaration of the intention of a testator with respect to his property which he desires to be carried into effect after his death. The testator is the person who makes the will. The right to make a will is the right to dispose of one's property according to directions given during one's lifetime. The main characteristics of a will are: 1. There must be a legal declaration. For example, a will by a minor is not a legal declaration since he is not competent to make a will. 2. Such declaration must be regarding the property of person making the declaration, that is the testator. For example, a will made by the Karta of a Hindu undivided family in respect of entire property of HGF is not valid. Number 3. The will shall take effect only after the death of the testator. A settlement of property by way of gift to take effect immediately is not a will. Number 4. It must be revocable during the lifetime of the testator. Even if it is declared to be irrevocable, the testator can revoke it or have a codicil. Codicil is an alteration or amendment made to a will. The law of wills in India is governed by the Hindu Succession Act, Muslim Personal Law, and Indian Succession Act. The various restrictions and provisions of these law and personal laws applicable to the testator have to be kept in mind while drafting a will. For example, a Muslim cannot by will dispose of more than a third of the surplus of his estate after payment of funeral expenses unless his heirs consent thereto after his death. Similarly, a Hindu co-parsoner can bequeath by will only his share of interest in the co-parsonary property. A will may be made contingent upon the happening of an event in the future. If a will is made in duplicate, retaining one copy with the testator and the other deposited in custody of another, the revocation of that is made by the destruction of the testator's copy. According to the provisions in the Indian Succession Act, no person having a nephew, niece, or near relative shall bequeath any property to religious or charitable uses except by a will executed not less than 12 months before his death and deposited in some place provided by law for safe custody within 6 months of its execution. However, this provision does not apply to Hindus, Buddhists, Sikhs, Jains, and Muslims. There can be a joint will, which is a will made by two or more persons in respect of their separate properties and or their joint properties. Yet in law, it will be treated as two separate wills. Similarly, a mutual will is one of two wills made by two persons giving each other similar rights in each other's property. The peculiarity of this will is that it becomes irrevocable after the death of one among them, and the survivor gets benefits conferred by the will of the other. One has the freedom to bequeath all his property to a stranger to the complete exclusion of spouse, children, or relatives, and such a will is called inofficious will. And yet, it is a valid will. The bequest made in the will can be classified under the following heads. 1. Specific legacy. 2. Demonstrative legacy. 3. General legacy. 4. Onerous or burdensome legacy. 5. Contingent or conditional bequest. And 6. Residuary legacy. There can be an executor of a will. An executor is a person who carries out the wishes of the deceased in accordance with the will. He is the person who distributes the estate to the legatees, pays the debts, and meets the funeral expenses of the deceased. The executor's assent is very much important to have a smooth passing of the property to legatee. The following factors should be kept in mind while appointing the executor. Taking the executor's consent to act as the executor is advisable. However, it is not mandatory. It is always desirable to appoint a person who is close not only to the testator but also to almost all the beneficiaries and heirs. One practical problem to be considered is that the executor must not be very old. If the executor predeceases the testator or dies immediately after the testator, there would be a problem. There can be more than one executor to take care of this eventuality. However, restrict the number of executors to 2. There is no bar on who can be appointed the executor under a will. It could be an individual, a firm of lawyers, or a firm of chartered accountants, a bank, or a company. A will has to have 2 witnesses. The only role of the witness to a will is to attest the fact that the testator has signed the will in their presence. They need not know the contents of the will. There is no prescribed form of a will, and it only needs to be signed, dated, and attested by witnesses. A will should be clear and unambiguous. The will may be written by any person, but then it should contain a clear statement that the testator has read it, understood it, and contains his intention truly and correctly. However, a beneficiary under the will should not write the will, nor should he attest it, so that any aspersion is not cast and thereby doubting the genuineness of the will. The will shall necessarily be in writing, except in the case of soldiers employed in an expedition or engaged in actual warfare, sailors at sea, or an airman so employed, who can declare their will orally in the presence of specified witnesses and other conditions laid down in the Indian Succession Act. A will can be registered under the Indian Registration Act, and there is no time limit for presentation of the will for registration. A will can be registered even after the death of the testator. This registration is done by the claimant filing an application before the registrar together with both the witnesses who signed the will and they making a statement to that effect before the registrar. A will can be registered like any other document, but it is not liable to stamp, can be written on ordinary or simple paper. A will can be notarized. It does not make much difference though. Notarization is not registration. Some points to take away. Advisable to take professional help to draft a will and the format to be followed. This will make the execution easier. A specific declaration that the testator is of sound mind. Name the executor with address to be mentioned. If the will is second or subsequent will, make a statement withdrawing the previous will with the date of that earlier will. List out the assets. Make a comprehensive list of all assets. Take some time to complete the list so that you don't miss out any. Divide the assets without ambiguity. Mention the asset clearly with the name of the person who will receive it. If the recipient is a minor, see that you appoint a trusted custodian for the minor. Witness's full name and address to be mentioned with the date of signing. Sign every page with the date and even time to have more clarity. A few jargons to remember. Intestate is when a person dies without leaving behind a valid will. Testator is the person who makes and executes a will. Beneficiary or legatee, the person or organization to whom you bequeath your assets in your will. Executors, the individuals you appoint to administer the distribution of your assets, it's generally a good idea to name more than one executor if one passes away. Probate, the legal document to be obtained by the executors after the death to obtain the authority to handle the assets. This is not mandatory. Administrator, a person who deals with the division of your assets if you haven't left behind a will. Codicil, a legal document which amends or adds to a will. For a codicil to be valid, it has to be written and executed in the same way as the will it seeks to amend. Nominees are not presumed beneficiaries. A nominee is a person appointed by the person investing in an asset. Upon the investor's demise, they are just caretakers of the asset and not owners. They are legally bound to transfer the asset to the legal heirs. The law of succession will be followed if there is no will. Therefore, in your will, it is important to mention whether the nominee is entitled to the proceeds of the asset or any other person as mentioned in the will. Living will. In 2018, the Supreme Court allowed living wills, which essentially deals with passive euthanasia. It means medical treatment can be withdrawn to accelerate a person's death if strict rules are followed. When is a will invalid? The burden of providing that a will is valid is placed upon the party putting forward the will. The court must be satisfied that it is the last will of a free and capable testator. But who is a free and capable testator? What disqualifies a person from making a valid will? Every person of sound mind, not being a minor, may, of his or her own volition, dispose of his or her property through a will. So this means that a will is valid if the person creating a will should be of sound mind when making it. A lunatic or idiot can never create a will. However, a person with Alzheimer's may create a will when he is lucid. Additionally, a person cannot create a will if he is inebriated at the time of its creation. A minor, a person below the age of 18, cannot make a will in India. A testamentary guardian is appointed to dispose of the property of a minor. If a will is created through coercion, it is invalid. This means if a son or daughter coerces his or her parents into writing a will in their favor, the will is null and void. Anyone can write a will, which is frequently done without the assistance of a lawyer. As a result, many people are dispersing assets that may not really belong to them. A wife, for example, may dispose of a house under her husband's name. Such a will is invalid. A will can be kept safely in the following ways also. Registered will. This is registered in book number 3 with the registrar's office, copies of which are not available till the death of the testator on request of the legatee with death certificate and other documentation. Sealed envelope containing the will can be deposited with the registrar. The seal will be broken when the testator dies on the request by application by heirs bar legatees. The registrar will retain the original will and pass on a copy to the concerned applicant. Will can be deposited with the bank in trust. The heirs can claim for the will from the bank on the demise of the testator with proper paperwork with the bank. The banks charge a nominal fee for this. Will can be under custody of a confidante of the testator. If the testator wishes, a trust can be created on the basis of a will for a specific purpose with specific objects as per the will of the testator as specified in his will. To achieve family security and to avoid or prevent the family disputes, it is but important to each and every one, howsoever small our estate may be, to draw up a proper will, appending signature thereto as a sign of wisdom, which emanates peace and harmony to the next generation.
Dear listeners, you have just heard Sri M.N. Pai speaking on the subject, Sign of Wisdom. This talk came to you from the studios of Akashvani Mangalore.